Welcome, everyone. Thank you so much for being here today. This is the first monthly immigration litigation roundtable that the CARE Coalition is putting on for a new monthly series where we're hoping to get to connect with you all with immigration practitioners around the country on litigation issues. We will be planning to give relatively brief trainings in the beginning of each roundtable, but we really do want this to be a place for like discussion and brainstorming, connecting, supporting each other. So please do feel free to put questions in the chat throughout. We'll have some moments throughout the training where we ask if anyone wants to weigh in, share about a case, share a comment. And at the end, we'll definitely have some time for discussion as well. If anybody's got questions on how things are going to work, let us know. I do want to also mention something very exciting that you'll be seeing us have a new name this summer. So for CARE Coalition's 25th anniversary, we are changing our name to reflect the fact that we are no longer just the Capital Area Immigrants' Rights Coalition. Our work is way beyond the capital area at this point. And so our new name is going to be the Amica Center for Immigrant Rights. Amica is Latin for the word friend. And so that's how we really view our work, supporting people who are detained and facing deportation and at risk of detention and deportation, being a friend, being a supporting role in that process. I believe I forgot to introduce myself as well. Sorry, we're just so excited. But my name is Adina Applebaum. I am the program director of CARE Coalition, soon to be the Amica Center's Immigration Impact Lab. And I'm here with two of my amazing, brilliant colleagues who are litigating these cases every day. So I'm happy to introduce you all to Senior Attorney Daniel Malo and Staff Attorney Kendra Blandon, who will be leading the training for today. So with that being said, I will go ahead and pass over to them to get started. Oh, I think I do have a slide though. Sorry about that, y'all. It's our first time doing the roundtable. Okay, so a little more about our work in terms of the Immigration Impact Lab impact litigation. So we're doing cases now at this point throughout the 3rd, 4th, and 11th circuits. We have been traditionally based in the 4th Circuit. That's our home base in the DMV region. But as we have seen ICE increasingly transfer people outside of our region to particularly Pennsylvania and Georgia and other places in the South, we have transitioned our direct legal services to go wherever ICE transfers people and do our best to provide people with access to counsel. In our Immigration Impact Lab, we are, very happy to receive referrals from you all on potential impact cases to push forward the law. We love partnering with you all, co-counseling, providing amicus support, taking cases up to the circuit court. We even have a case right now at the Supreme Court. And like I said, each month we'll be doing these roundtables to connect with you all and hopefully share some training that can be supportive for you all. And then after this training, tomorrow I'll be sending the replay. I'll be sending some model briefing that is for these claims at the 3rd, 4th, and 11th circuits, which I know folks are excited about to get those. I'll be sending also the tracker we have of particular social group claims that we're seeing, led by Senior Attorney Evan Benz, who's been tracking that for some time. And then also some favorable IJ and BIA decisions in this area in case they're helpful. Now I think I could finally turn it over now. Thank you so much.
Thank you so much, Adina, and thank you all for being here. Today we're going to be talking about gang-related fear-based claims, and we're going to get started with some general tips on issue preservation as well as Nexus. Next slide, please. So first and foremost, it's essential that when you're representing non-citizens before the IJ that you preserve all potential PSGs in your briefing. Per matter of WYC, the BIA cannot consider new particular social groups on appeal. So we want to be sure to preserve all formulations of your group, whether that be in a footnote or during your oral argument. There is always a risk that proposing more groups than necessary will overshadow or dilute your strongest claim. So of course, do your research and present your strongest argument first, but we always want to reserve those issues on appeal so that you can continue the case if need be. Our second general tip is making sure that your client's declarations, their family members' declarations, their friends' declarations include specific details of the persecution or torture that they faced. Often some of the declarations that we receive will be too general. For example, they'll say, my brother needs to stay in the US because something terrible happened to him. They are coming after him and he's in danger. And unfortunately, the IJ will look at that declaration and say it's too broad, it doesn't identify the persecutor, any incidents of torture, etc. And so even though it's not a particularly natural way to write, we do want to encourage all of our supporting declarations to include as much detail as possible. And then lastly, the importance of supporting evidence cannot be overstated. These claims are highly factual. The immigration court does not follow the federal rules of evidence, and that's often a point of frustration, but we can use it to our advantage. For example, you could use Google Maps to search where did incidents of persecution occur. If you can find on Google Maps the house or the school or the place where something bad happened, not only will it allow the immigration judge to visualize what your client is talking about, but it will also provide some corroboration. I remember that the door was blue. I remember that the building had 2 stories. And so even when you feel that maybe your client doesn't have strong corroboration, always think about Google Maps and other creative ways to find supporting evidence. Next, we're going to talk about proving nexus, one central reason. Next slide. Thank you. So you can go to the next one as well. Thank you, Adina.
And Kendra, we got one question in the chat. Does the PSG have to be in the I-589, or is it sufficient to be in the brief for preservation?
It's sufficient for it to be in the brief. The I-589 will often be filed, sometimes even years before a case gets to you, especially in the non-detained context. You can also, if the I-589 didn't have sufficient details, you can submit an updated I-589, and including those additional PSGs at that stage is allowable.
Awesome. And if anyone knows of a source on that, please add it in the chat for the questioner, and I'll let Kendra continue on Nexus.
Thank you. And so another important consideration is the pesky nexus, which often is really what these cases turn on. And so a few ways for you to demonstrate that the persecution or past persecution or torture occurred on account of a protected ground is thinking about the time between a persecutor learning that your client is a member of the group. How long after the persecutors learned did the persecution begin? You can also consider the timing between threats and incidents of physical violence. In the Third Circuit in Voci v. Gonzalez, it was a case where a non-citizen was threatened by a known group, but was later attacked by an unknown group he couldn't identify. He didn't recognize the people who kidnapped him. He had a blindfold. He just really didn't know whether the incidents were connected. But based on the short time before the threat and the attack, the immigration judge was able to conclude that the known group had made good on their threat and had made that threat credible. A second important tip regarding declarations is being sure to ask your client what persecutors said before, during, and after attacks. A persecutor's motivation or reason for coming after your client is the most essential component of nexus. For example, if you're presenting a domestic violence claim or a gender-based PSG, evidence that the persecutor used words like, "you are my woman" or "you are my property" is essential. The slurs that they used, the bad words that they used, this is always an uncomfortable conversation. I've had clients tell me before, they just said bad things that made me feel terrible. And I'll have to explain that those key words can mean the difference between losing and winning a case. And especially if you see that your client is apprehensive, you can make them feel better. Say, I know you're a lady, I know you're a gentleman, and that you would never use these slurs or these curse words in your everyday life, but I need you to either tell me or write down exactly what they said to you to help you prove Nexus. And then finally, you can ask your client who else was or was not harmed by the persecutor. And that will help you understand the motivation of a persecutor, asking about coworkers, family members, friends in similar circumstances. And if you learn that there are cases of forced disappearances or that a loved one has passed away, maybe Google will have some information. So always Google the names of lost loved ones just to see if news articles came out in their home country and to have those things translated. And so now I will turn it over to Dan for an overview of the different types of claims that you can raise.
Thanks, Kendra. So we've outlined here what are essentially six of the big kind of categories when it comes to gang-related fear-based claims. And we'll just note up front that what we're going to spend the bulk of our time on here today is the first three. It's not to say that the back half are not entirely viable. They've just been very hard to win. And so far have not had a lot of success in terms of PSG formulation. Next slide, please. All right, so for the three that we're going to focus on today, the family-based PSGs, these are the ones where family members of a gang member are targeted by a rival gang, maybe by the government to try to find the gang members' whereabouts, or maybe to get other folks in the family to join the gang, right? Imputed gang membership here, similarly, right? Like not unlike what we're seeing right now happening in El Salvador with the state of exception, where any reason just about is enough reason to impute gang membership to someone. Here again, we find that PSG is formulated around this, right, where society is targeting, or rather certain actors within society are targeting a group of people based on certain characteristics, fearing, again, torture, enhanced interrogation, unlawful detention, has been a successful PSG formulation. And then last but not least is the witness and informant PSGs that have had some traction at the BIA and the circuit courts, where again, you've come forward and helped the authorities by reporting a crime, being a witness for the prosecution, things like that. Next slide, please. And then here are the other ones that I'll just touch on briefly, but we won't delve in too much since they haven't, again, gotten a lot of traction as PSGs. Courts have consistently found that prior gang membership is not enough to constitute a PSG, and so that means that even if somebody wanted out of the gang, was being persecuted by a rival gang, or is even being targeted by their government, is not necessarily enough to rise to the level of PSG. Gang recruitment claims, once again, often for fairly young folks and fairly dire situations, is still consistently has not gotten traction, not been successful in formulating a PSG. And then last is the gender claims, specifically within the context of gang-related fear-based claims. Have folks, again, have struggled to find success in formulating PSGs here, and even where, again, folks are forced into recruitment into the gang or being forced sexual partners, have not had any success getting this as a PSG. I'll hand it back off to Kendra to talk about family-based PSGs.
Thank you. So as Dan mentioned, there's two categories of people here. There's family members targeted because their loved one was a gang member. This will also be something for you to consider for imputed gang membership claims. But more often than not, these family-based PSGs arise when one of your client's loved ones was the victim of a gang and either went into hiding or has passed away, but the gang still feels that the family owes them something. The most recent BIA case on this is matter of MRMS, where the BIA ruled that when a persecutor is targeting certain family members as a means of achieving an ultimate goal, unrelated to the protected ground, the family, that the family relationship is not one central reason for the harm. An important thing to note is that these family-based cases will often have issues related to Nexus, where the fact finder will struggle to conclude that the family is the reason for the persecution. More often, the IJ will say, this wasn't about the family, this was because the gang wanted an extortion tax, or they wanted a piece of land or a piece of property that the family owned. Note as well that while that may be true, that the gang wanted some other piece of property or money, that doesn't mean that the family membership was a central reason for why the gang continues to come after your client and your client's family. And note that even if your client can't meet this higher Nexus standard, the Nexus standard for withholding under the INA is lower than the asylum standard. And we invite you to join us at our next roundtable on May 2nd, talking about that lower Nexus standard for withholding cases, as well as our presentation on June 6th, where we'll really dive into matter of MRMS more. But to provide more information here and now, in the Third Circuit, there have been several favorable cases, including Kamara, where the applicant was granted relief after her father was kidnapped in front of her and other family members were threatened by a criminal group, even though the gang stated that the reason for the kidnapping was because the father, and by extension the family, owed them a large sum of money. In the Fourth Circuit, family, especially a nuclear family of the parents and children, is a well-established PSG. So particularity, social distinction, and immutability section can be brief. The main section to know here is Crespin-Valladares, which held that social groups based on innate characteristics like family relationships are generally easily recognizable and easily understood by others in society to constitute a social group. In the Fifth Circuit, Diaz reversed a BIA decision where the BIA failed to reopen a case, where the BIA discounted an affidavit that demonstrated that the cartel was persecuting family members. And so we'll take a moment here to pause, since we've thrown quite a bit of information at you. And so just wondering if there are questions in the chat, or if y'all have encountered these family-based PSG claims before, and any hurdles that you encountered or perhaps are still thinking of how to overcome.
Thanks, Kendra. Yeah, we already have people asking for the replay, so I can tell folks are learning. And we have one question from Julia Regal. Apologies if I'm pronouncing your name correctly. She's asking, would you say that a gang girlfriend type of case involving severe domestic violence, would the ARCG type PSG have a better chance of winning than something to do with an abusive partner being a gang member? I would think yes, given you can cite to ARCG, but I'll see what you have to say, Kendra, and Dan, if you want to weigh in.
Yeah, I'd certainly agree with that. And I think in that case, that's a great example of where you want to preserve multiple versions of the PSG. You can have one that focuses more on, women unable to leave domestic relationships or unable to leave the marriage. We're here where we're talking more generally about gang girlfriends, especially if other members of the gang have told, most commonly the woman, you can't leave, you are his or our property. I think that's where it gets a bit more complicated. But the short answer is I think you're exactly correct, but would still recommend preserving all those issues and those PSGs.
Thanks, Kendra. Dan, anything you would add to that? Okay, great. If other folks have questions or want to share about a family-based case, please feel free to go off mute or put in the chat before we keep going. We'll give folks a minute. Okay, looks like we can go forward. Next up is imputed gang membership PSGs.
Excellent. And if you would go to the next slide, please. So when would this come up? This would come up if your client says that they're from a country that frequently detains and tortures actual or suspected gang members. The most popular type of case we're seeing right now is folks from El Salvador. Our CARE colleague, Catherine Gordon, recently presented a webinar on El Salvador's state of exception, under which the government has significantly rolled back due process procedures and constitutional protections, including mass trials of hundreds of people at a time. Under the state of exception, it requires all deportees from the US with criminal records to register themselves with the government. Conservative estimates say that over 75,000 men have been detained, and we have country conditions evidence documenting torture in over 100 cases. The photos and the accounts from the state of exception are quite egregious. And so while El Salvador is the most recent case where we're seeing torture occur among detainees, by no means is that the only country where it occurs. You may want to put forth this PSG if your client has tattoos or piercings, if they have criminal history abroad or in the US, especially if they've been issued a gang card by law enforcement. This came up in a case we litigated recently in Frederick, Maryland, where the local law enforcement identified our client as a gang member. And so all of his documents now say that he is a gang member, even though he swears up and down that he isn't. You can also put forth this PSG if someone has faced or is facing gang recruitment, if they've done favors for the gang as an affiliate, or if they have family members or close friends in a gang. If you think this PSG might apply to your client, we would highly recommend using FOIA requests and getting all of their criminal history and searching for gang cards, in addition to doing country conditions research. And the PSG there is just the type of nationality men labeled gang members by US law enforcement.
Thanks, Kendra. I was going to share a quick example of a case we've had in the lab team pending for several years with this exact PSG. It's currently pending at the board, likely to go up to the Fourth Circuit on this claim. So if you have a client with this potential claim, definitely preserve it in case there is the possibility of good law on this PSG. So our client, he was really someone just in the wrong place at the wrong time. He was coming back from soccer practice in Virginia, and a gang fight broke out. The police arrested everyone in the area, and he was facing very serious gang participation charges in Virginia. He actually received a full Padilla consult from his defense attorney advising him of the immigration consequences. And under the advice of counsel, did decide to plea to the low-level gang participation offense, given that he was facing much higher offenses in a conservative county in Virginia that would not have a jury looking fondly on gang charges. And so he was aware the whole time of this and made an informed decision. We actually were able, our amazing direct services teams were able to persuade the immigration judge that he was a credible person and that he was not actually a gang member, and give the context of these convictions. And she found that based on the Virginia conviction, he was wrongfully labeled a gang member by US law enforcement and by Virginia, given that it was put in his I-213 that he was a gang member. And so we've been litigating that case for years, and that's just an example of how you can kind of turn like a racial profiling situation potentially into a hopefully viable PSG claim. I see in the chat there are some really good comments coming in. I wanted to highlight you, Andrea, if you're able to come off mute by any chance, it'd be great to have you share a little bit about what you put on MRMS. No worries if you're unavailable. Oh, thanks.
Can you hear me okay?
Yeah.
Yeah, my headphones are sort of broken. I was just sharing that MRMS is a very badly written decision. So rather than being intimidated by it, I encourage everyone to read it very closely and then argue against it, particularly in the Fourth Circuit and the Third. They're really good circuit decisions, and the Seventh, although I don't know if we have anyone here from the Seventh, but that it changes the one central reason standard, but that's a statutory standard. So really focus on the one central reason as a reason for harm. And what it says is not only do you need to demonstrate harm on account of particular social group, but that on top of particular social groups, the harm has to be related to another protected ground. Well, that's not what the INA says. The INA says you have to face harm on account of one protected group, and that, doesn't need both. It's not if it's a particular social group, you also have to show harm on account of another protected class. So I really want to emphasize that, point out it's a very bad decision, and also it has no discussion of the fact that the BIA analyzed with respect to how the family relationships, how the family dynamics, how whether or not multiple family members were being targeted because of their family relationships rather than the land that they owned. And you can distinguish by really zeroing in on the facts in your case and make individual arguments for each individual person, rather than, in that case, it was consolidated. So there were multiple family members and sweeping decisions made about all of them in one decision, rather than individual analysis of how family relationship might have been differently applied for each of them. That was my rant against MRMS, and hope that it gives everyone fuel to keep making those claims, particularly in circuits where they're strong.
Thank you so much. This is exactly what we're hoping would happen in these roundtables, is that people share their insights and can learn from each other. So thank you very much for sharing that. And as Kendra mentioned, we'll have a whole roundtable on MRMS in, I believe it's June. We got a couple more questions coming in. We can maybe just address these two and then go on to the next item.
Sure.
So Adriana is asking about if thoughts on formulating a PSG for men from El Salvador labeled gang members who were subject to the ICE data disclosure.
Yes, and so what we've seen most frequently is that ICE has admitted that there was wrongdoing, and so even for individuals who are further along in the court process, they allowed the proceedings to reset so that practitioners would be able to put forth this PSG. I think at that point, again, preserve all the PSGs, have one for Salvadoran victims of the ICE data breach, have another one for imputed gang membership, etc. I was reviewing this one decision recently where there was a dispute about what documents the US government would send to El Salvador with the non-citizen. And it was quite frustrating because the government, the DHS, was arguing that we don't have evidence that the US government will send the gang card. And that felt very circular, because wouldn't they be in the best position to tell the judge what really is sent over and isn't as part of our data sharing agreement? The US and El Salvador have a very extensive information sharing agreement and a database, and yet they would not allow the presumption that we would send the full criminal record and the gang card. And so that was particularly frustrating. That case ultimately came down that even if we think that the US government wouldn't send the gang card due to the person's tattoos and that their family members were also part of the gang and had already been detained under the state of exception, the judge still ruled in favor of the non-citizen getting cat relief. But it was quite difficult having the government say that, well, we don't really know if the government will send the gang card or not. And to the second question, to Michelle's question about paying extortion demands, I think you're correct that could also perhaps lead to a possible imputed gang member issue. I would caution you to also just be aware of the material support bar and to make it very clear that your client paid the extortion demand under duress, under threat, that they tried perhaps to relocate or evade the gang. But we've seen cases where even where family members have paid extortion demands, they are still granted relief when it is under duress. And so maybe now we can continue to the next slide and talk a little bit more about the case law around these imputed gang membership claims. Speaking of poorly written decisions, let's talk about matter of EAG. For you legal history geeks, this was the first time that the BIA added 2 new requirements for the PSG test. Even though they had previously referenced the concepts of social visibility and particularity in matter of AME and in matter of CA, they never made it a requirement until this case. And what they held here is that young persons perceived to be affiliated with gangs cannot be a recognized PSG because it is inconsistent with the principles underlying the bars to asylum and withholding based on criminal behavior. Let's say that again. The BIA here says that someone with no criminal history who just quote unquote looks like a gang member cannot be granted asylum because they look like someone with criminal behavior. And so it was a really funky decision. This is a quickly developing area of law, but just wondering for some gut reactions to matter of EAG and the presentation of these two new components of the PSG test.
Yeah, maybe we can say if you have seen that come up in one of your cases, put a 1 in the chat so we can just get a sense of like how much this is coming up.
Yeah.
Or if this is the first time you're hearing of that.
And yet even with those new requirements, even with the BIA stating pretty expressly that they don't want to grant relief for imputed gang members, we are seeing some differences in the circuits. For example, in Chavez v. Garland in the First Circuit, they remanded a withholding case for further consideration of whether imputed membership can establish PSG. If you're in the Fourth Circuit, you want to analogize to Martinez, but distinguish from Zelaya. In Martinez, the Fourth found that former MS-13 members from El Salvador is immutable. And so to the certain extent that you can use that case to say that imputed or perceived gang members should also be imputed, that's where you want to analogize. In Zelaya v. Holder, they held that the characteristic of resisting gang membership does not provide an adequate benchmark for determining particular social group membership. In other words, it's unclear how amorphous the group is. What does it mean to resist gang recruitment? Does that mean that your client just walking to the other side of the street was resisting gang recruitment? How are they different from someone who actually had a verbal or physical altercation with the gang? And so as much as possible, you want to argue that the lines for who is and isn't an imputed gang member is pretty clear, especially when you consider criminal history. In the Ninth, Vasquez v. Garland, they remanded an imputed gang PSG, and the court noted its prior concerns that were raised in matter of EAG. And they said that Congress may not have wanted to reward gang members for their behavior by recognizing them as a social group, but that concern does not apply when the membership is imputed only, when it is based on an erroneous belief that the applicant is a gang member. And so if you hear these types of things coming up in your cases, make it very clear that your client is not actually a gang member. They were in the wrong place, the wrong time. They had this tag placed on them, and that is now causing all of these consequences for them. The Seventh and Tenth Circuits have also held that the considerations barring asylum applicants from proving eligibility do not apply equally to people who claim they were persecuted because of perceived gang affiliation. And so that's that for imputed gang members. You want to analogize to imputed political opinion claims. You want to argue that where possible that the criminal bars don't apply, but more importantly than not, expressing that because of the imputed gang membership claim, they're at risk not only from the gang that perhaps they've been avoiding, but also from rival gangs and from governments who may seek to unlawfully detain and torture them.
Thanks, Kendra. I'll just add 2 quick things. A common sense way to think about this that I have heard resonate with a conservative IJ before is like, yeah, we want people to leave gangs, right? Like we want to incentivize that. So that's sort of the emotion you want to pick up on, I think, to make this a compelling case for a judge. And then for those in the Fourth Circuit with Martinez, something we're often trying to really establish factually in these cases under those claims is like all of the very specific steps that the person took to leave the gang. In the Martinez case, it was a very affirmative act. So these claims are weaker when someone was a bit more wishy-washy in leaving or kind of like left without making noise about that, right? So draw out with your client, like what are all the steps you took? Who did you tell? How did they find out? What did they say when you said you were leaving? And so on. And I'll turn it over. I believe Daniel's up next.
Yeah, thanks. So let's cover here witness PSGs. The formulation for this one is typically fairly straightforward, right? It's someone coming forward, usually the authorities, having witnessed or been themselves a victim of a crime. And so to start us off for once, the BIA actually has some helpful precedent here in HLSA. While they actually ended up denying the non-citizen CAT and withholding, they did find that where someone comes forward, very publicly cooperates with law enforcement, testifies at trial, and that there's enough evidence in the record that the society that they're in recognizes that we should be protecting witnesses who come forward and assist law enforcement, that could be a PSG, that might be enough. In the Third Circuit, we actually have this PSG going all the way back to 2011, and it's reaffirmed here in Guzman-Rayana that witnesses who publicly provide assistance to law enforcement is enough for a PSG. And that, unfortunately, is where the good case law ends. Here in the Fourth, where we're usually a little bit better off in this area of law, Herrera Martinez v. Garland found that prosecution witnesses just isn't a distinct enough social group. It doesn't meet the particularity requirement, particularly where the witness hasn't publicly testified in some way. Next slide, please. And then turning to the Fifth Circuit, Hernandez de la Cruz, very similar thing, former informants that are assisting law enforcement is not a socially distinct enough group. And Castillo Arias in the 11th Circuit, once again, non-criminal drug informants that were in Colombia were not part of a social group, in part because they did not have an immutable characteristic, a visible immutable characteristic here to distinguish them. And so I'd float to folks out, hopefully it may have come through in just describing the cases. I think there is sort of a pivotal difference between the claims, the PSGs that were successful and the ones that have not been, and I'd be curious if other folks caught that thread.
Yeah, a little pop question for you all. Pop quiz, I mean. Just to reiterate Dan's question, what do you all think is that distinguishing factor we're seeing in these witness cases? Anybody got it? Feel free to go off mute. There we go. We got some people in the chat.
Yeah, I think that's spot on. I think the public nature of the testimony is really crucial, right? I think you're facing a much higher uphill battle if the person that you're helping only cooperated in private, submitted reports, maybe even was actively assisting over time with the investigation. But that public nature is, I think, crucial to having this PSG land.
And I'm coming off mute to once again plug, even if somebody didn't testify in an open courtroom publicly, which is like sort of what they talked about a lot, there's ways testimony can be public in a community. So just think about and develop those facts. Even if the person didn't stand up in a courtroom, if everyone in the community knows that they testified, I mean, you can try.
Great point also. Yeah, thank you for adding that, Andrea. And great point by Emma in the chat about ocular visibility. Emma, are you able to go off mute and share thoughts on how folks could push back on that? If not, no worries. I know people are multitasking with these things. Or Dan, do you have any thoughts on the ocular visibility piece?
Right, I think that there is room to, and definitely I think worth pushing back against that idea that it has to be, to Andrew's point, like actually physically visible at all times, right? That immutable piece necessarily needs to be visible. And it makes sense, right? Because if you try to square that with someone's gender identity, for example, that's not a visible characteristic, right? So I think that there is good case law, and hopefully we can continue to keep it that way in terms of not allowing that to grow or to fester into a more physically visible requirement.
Thanks. Well, I think that covers all the substantive slides we had. So at this point, we'll open up for questions, just make a plug on our end. Again, like in the beginning, if you have any cases that you want us to take a look at for impact litigation, please do feel free to reach out. We have recently streamlined our process, so you don't have to fill out a form. We do have a form if you want to make it easy, but you can just email us at lab@carecoalition.org, share a little bit about what case you have in mind. We're happy to take a look, and if it is one that we think is viable and ripe to challenge, we can perhaps offer co-counseling, amicus support, perhaps take the case off your plate or place it with pro bonos at law firms. And I will open it up for questions. So I'm gonna stop sharing. I think that's all our slides, right? Except I wanted to mention the upcoming roundtables. That was it. So these are subject to change. This is what we're thinking for the coming months for the rest of 2024 of what topics we plan to cover. We'd love to hear your feedback if you're particularly interested in hearing any of these. Make sure we cover them, or if there's like something missing that would be particularly helpful for you all, reach out. For those of you who registered, it should be like a recurring event that you registered for monthly. We'll have it the same first Thursday of every month at 3 p.m. Eastern. I think there's maybe like 1 or 2 off months where it's a holiday, maybe July 4th or something. In that case, I'll just send a new invite link or something. We'll figure out when we get there. But that being said, I'll stop sharing and we can chat a little bit. We've got about 15 minutes left. So if anyone wants to share a case that they've done in one of the claims that's been discussed, we'd love to hear about how it went for you, what you're seeing work in the local immigration courts, at the board.
I'll chime in. I'm Adrian. Work at Immigrant Defenders Law Center in Los Angeles. I'm actually currently in the middle of individual hearings. My client we're submitting PSG on imputed gang membership. My issue, and I don't know if any other practitioners have seen this as well, is that the IJ was very, I guess, critical of when I had country conditions experts testify as far as the statistics of, harm, even if they were to consider, this individual as potential, imputed gang membership. So I just kind of wanted to run it by anybody if anybody had any other tips on, how to wrap this case up if it looks like the IJ is being pretty hostile towards, statistics of harm and, statistics of detention, considering the population, even though the state of exception is obviously pretty clearly documented.
Right, and just to confirm, your client was from El Salvador, right?
Yeah, that's correct.
Yeah, I've seen the same pushback as well, and internally we've been referring to it as funky math, where the IJ will say, okay, 75,000 people are detained, they're having terrible food quality, they're being kept up all night because the lights are on 24/7, but only a few hundred of them have been put into stress positions or other forms of torture. And so what I'm hearing you say is that your judges engaging in that kind of funky math and saying, well, even if they're detained, the odds that they specifically will be tortured is 1 in 75,000. And sometimes I've seen a judge say that, just poor conditions of confinement does not equal torture. And so in my opinion, they're moving the goalposts back, because at that point, what they're essentially saying is that if everyone is being tortured, then only the most egregious forms of torture will be considered torture. And it's this like weird double speak. They're doing this weird calculation. And so as much as possible, I would stress that it's not just poor conditions, poor food. It is documented evidence of threats of solitary confinement. There's evidence that the men are forced to like run down a row of officers and will be beaten. And so as much as possible, I would stress that it's not the poor conditions your client is concerned about, but it's more these extensive documented reports of physical violence. Another pushback we've seen here is that they'll say that the rhetoric used by President Bukele saying that he wants to kill gang members, that's just political rhetoric. That is not government policy or indicative of specific intent to harm and torture. I think that's really egregious and erroneous, and I think you can push back on that by saying that the statements are indicative of specific intent, that it is a government policy to harm and torture actual or suspected gang members. And I think all of us should really push back against that type of funky math and the shifting of the goalposts back.
If I can add one more question to that same case, I guess for anybody else that might also have some of the same issues of like an IJ who's seems more of a government advocate, same judge, same situation, essentially had more questions for my experts than I did on direct. It was almost double in one instance where I had direct for like 50 minutes and then IJ had an hour and 45 of what I would call her cross-examination, which I thought was totally improper. But any tips on actually within the hearing, even like just to preserve the record, how can I guess, respectfully object to her line of questioning?
I don't know that there's any decision on this in the immigration context, but at least by analogy to real courts, everything the judge asks is exempt from the requirement that you preserve an objection on the record, because why would the judge need to be objected to, and wouldn't they overrule your objection if they're already doing it? I think it's, at least my guess would be, it's fine not to object to every single stupid question and just leave it as still preserved for appeal.
And I'll just jump in here and I would just say that I would also push back a little bit. I've had judges who are like, I'm going down my line of questioning, and then they constantly want to interject because they want, to what I feel is to intimidate my client based on the questions they're being asked. And then I just kind of just redirect the judge and put it on the record as a judge, if I may, finalize my line of questioning here and, allow me to flesh out the point I'm trying to make at this point before the court interjects. That's work sometimes. I kind of say it respectfully. And then if not, what I've done in the past sometimes is, if the judge will allow me, like after the judge questions, then I kind of just shift to kind of like a redirect, but based on what the judge said that, just didn't come out quite right, or it's just, if they're just dumb questions that really don't go to the substance, I don't make an objection. But if it's something where the judge is making it so that the testimony kind of seems to twist and it seems like it's going to go the wrong way, I sort of just redirect, like ask questions, redirect to kind of rehabilitate a little bit my client, you know, kind of on the spot is my suggestion.
Thank you all. I appreciate it.
Really appreciate folks weighing in and giving each other advice. Again, that's exactly what we were hoping this space would become. Are there any other questions folks have on formulating PSGs or case examples they'd like to share with others?
I guess I'll just chime in and say that, you know, I'm in the 11, so I'm in Miami, and a lot of times you know, when I do these kind of cases, I never want to use the word gang because it's like all these sirens go off in the IJ's, you know, ears and eyes, you could just tell. So, you know, I sometimes tend to use and call them like illegal arm groups, you know, I'll call them, you know, other kinds of stuff except gangs, you know, just to try to frame it out of the gang, because the minute you say gang, they kind of, you know, the judges kind of just roll their eyes and think like, oh, this has been denied before or whatever. So, you know, just sometimes just even, you know, transnational criminal organizations using those kind of wordings, you know, has worked in the past for me. So, not using the word gang has worked for me in the past.
That's super helpful. Thanks for sharing that tip. Question for Kendra and Dan, anyone else who wants to weigh on this. Do people have thoughts on how to differentiate the one central reason when there's issues of like money, extortion, land, all going on?
I think that once again, right, like being able to build up your declaration. Obviously, a lot of times when clients come to us, the stories are a bit convoluted. Folks don't necessarily remember what order things were, or assign certain values to certain facts ahead of them telling you them. And all of that's to say that I think, especially when trying to hone here in this particular context, really thinking about like what's the PSG you're putting forward, and then how do the facts, what your clients are telling you, help clarify that for the IJ, and what are the other parts that might provide DHS or the hostile IJ a way of like squirreling down and finding a reason to deny, right? So really building yourself an island sort of thing, saying like, we're not saying that nothing else was involved, but being able to point to this was the primary reason, the one central reason, not even the primary reason, the one central reason, I think goes a long way.
Thanks, Dan. That's really helpful. Anyone else have insights on this? We've got about 5 minutes left and then we'll wrap up. Okay, well, it sounds like we might be wrapping up early. Thank you all so much for joining us. This was a really great first roundtable, much more engagement than we were expecting. We were a little nervous it would be just us talking. So thanks everyone for stepping up to make this a helpful space for everyone. And we look forward to seeing you at the next training, May 2nd. I'll be sending out the reminders and all of that. And stay in touch. Take care until then. Thanks again. And thanks to Kendra and Dan for a great presentation.